Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our community conference call held every other Thursday, 12:30 p.m. Eastern Standard Time. We are answering these questions under the terms and conditions that you heard when you logged in. I will go over the questions one by one. Today I have not marked anything as a frequently asked questions because I think most of these questions are highly unique to every situation. And at the end of answering each question, I will invite your input. Let me rephrase that. I will invite follow-up questions on that topic. So please don't introduce a new topic. Only ask follow-up questions. Time permitting, at the end of the call, we'll take up new questions. I think we should have time to take up new questions today. With that said, let me just make sure that everybody can hear me okay.
The conference is now in conversation mode.
Could you folks please confirm
Yes,
if you
can
can?
hear you.
Good, excellent, thank you.
The conference is now in presentation mode.
Before I get started, real quick word. There has been a release from the State Department further clarifying the Indian visa ban. I'll have something up. There's just a couple of points to note there, maybe 3 points. I'll have them up later today. As soon as I finish this call, Monica, our technology person, is detained in India because of the COVID situation. So I'm going to be wearing many hats. Might get things a little bit slower than usual, but I should have the conference call recording up by the end of the day tomorrow, and the visa questions or updates by the end of the day today. With that said, let's get started with the questions that have been posted on our forums. That's forums.immigration.com. I don't know if I remember to announce the date. Today is May 13th, 2021. First question. I am currently on L1B with Company X. Company X applied for my H1B in March of 2021. Good, it got picked up. Now they are applying it as a change of status to H1B. But I'm also interviewing with another company, Company Y. Can I join Company Y before October 1st, 2021? See, the problem with this, Ashwini, is rightly or wrongly, I think it's wrongly, the USCIS considers your H1 not to have been activated until two things happen. Until the new fiscal year begins, which is October 1st, and until you receive a change of status or an H1B visa if you're outside the US. Why is this incorrect? I don't think change of status or visa stamping has anything to do with you being exempt from the quota. USCIS agrees or disagrees with us in theory. In practice, we have received many approvals in these situations. What do you want to avoid? So what you want to avoid is this. You want to avoid one of the two situations, one being absolutely fatal, second being probably fatal to your H1B. First situation you want to avoid is that your company withdraws the H1B before it gets approved. So if they don't file or it doesn't get approved, you have got nothing. You are still subject to the quota. Number two, you want to avoid the situation where the new fiscal year has not started, which is October 1st, and your H1B gets withdrawn by the old company. So it appears to me the best thing to do is to wait till at least October 1st, assuming that your H1B is already approved, then ask for a transfer over by a new company. Do you need to get a visa stamp? No, if you get a change of status, you do not. How long does the H1B transfer process require? So if you are going from H1B to H1B, you don't really care because you can join the new employer as soon as the transfer petition is filed. Along with that, remember that you can also file premium processing. That makes life a whole lot easier. Okay. Ashwini, if you are here and you have a follow-up question, press *5 on your phone. Anybody who has a follow-up question on this topic, nothing new, press *5. Okay. Let's go on to the next question. So actually this is incorrect English. What they mean is effect of dependence, not effect of dependence. I'll correct that typo later. Hi Rajiv, I included my family member, spouse and son as derivatives in the EB3 downgrade last year. I'm on H1B, my family is in H4, all of us have got the EAD and advanced parole. If my wife or son use the EAD for employment, will that affect H1B? No, sir. Your dependents' use of the EAD or advanced parole to travel will not affect your H1B. Only your own will. You can affect them, but they can't affect you. Okay. *5 if you have a follow-up question. *5. Okay. Next question. Oh, there is a question. Let's see. This is from area code 805. 805, where are you calling from?
I'm calling from Illinois.
From Illinois. All right, sir. What is your follow-up question?
Yes. So, the EAD card that I received, but for my son, he just is turning 21 this year.
Mm-hmm.
So, but the USCIS did not. Is that a process to send a Social Security card also at the same time, or do I need to contact the Social Security Administration separately to get a SSN?
You do.
He needs to apply for a driver's license.
Yeah, okay. You need to get the contact Social Security Administration and see what you need to do to reflect the work status on the EAD. By the way, I am a US citizen, but my Social Security card still says not valid for employment from back in the student days. I never got it changed. So it's not a big deal, but you should get it done. Paperwork should always be in order. Okay?
Okay. There was also one related question, but not.
That's okay. Go ahead and ask. Go ahead.
Yeah. So my son actually, I applied for the downgrade. So I received the EB3 EAD as part of the downgrade process, right? Mm-hmm. But we use the date of filing approach. Mm-hmm. So the USCIS issued the EAD card.
Yeah, he's gonna have a problem unless the filing dates, or not the filing dates, the final action dates become current before he turns 21. What is the problem? He will not be protected by the CSPA. So he will need to seek his own independent H1B status. Okay?
Okay.
The reason I said...
Actually, he's a student.
Yeah. So by the time he's done with school and all...
So
Go ahead.
Yeah, so the EAD card actually they issue till next year, which is past his date of birth, which is when he's turning 21, right? So probably that EAD is not valid till next year, right?
Well, the EAD
go way beyond his 21 years.
The EAD will be valid from the date it says it is valid from. Okay, and that EAD should not have anything to do with his date of birth. But I don't know, whatever the reason is, you can check with your lawyers. There should not be any correlation between the date of his age and the EAD. Nevertheless, the situation about the protection of his age under CSPA is only possible if the dates of filing, final action dates, become current before he turns 21, minus the amount of time the I-140 kept pending. The EB3 downgrade was kept pending. Okay?
Okay. So my understanding is that he can continue to use the EAD card way past his 21 years, since that's what the USCIS has issued to him, right?
Absolutely.
Absolutely.
Until they revoke his EAD, it is good to use.
Okay. So that's good to know. Only thing, the next time when I go to renew, they might not allow me. Right?
Yeah, my problem is, well, first of all, they would have to trash his entire application before they can get to his EAD. And number two, by the time, hopefully, fingers crossed, he's ready to get into his H1B, he'll be good to go. Now, his pending 485 can become a problem for something like OPT or STEM OPT, but we'll see when that happens. Hopefully, by that time, this situation with the dependent children aging out gets resolved under the new laws, under new policies. That's a little bit way off, hard to do, hard to plan for, but right now I think this is the best thing you can do. Go ahead and use the EAD if you need to.
Okay.
Okay?
Sure.
I gotta take my next, I gotta go on. Sir, I can't give you any more time. I gotta go on. Okay. Sorry.
Yeah.
Good luck. Yeah, I gotta cover everybody's questions. So we can't spend a lot of time, but I try to answer all the essential questions. Next question, number 7. So I-485 processing time, family-based and wait time for approved I-485 starting additional part-time job. Okay, this is confusing. My employment-based I-485, which was filed in 2012, got approved. Okay, so you got your green card. We could file my wife's derivative only in October. So before you got approved, you had already filed her 485. Good. She has not yet received her 485 based EAD. So her H4 I-94 is expiring. Can she continue to stay? And the answer is yes, because her I-485 was properly filed and accepted. Double check with your lawyers unless there is a problem with the 485 filing. If your 485 got approved after hers was filed, she's extremely legal. I'm using really bad English, but she's definitely legal. But not only that, the fact that you were maintaining H1 status until you filed her 485, I see no problem with you having gotten your green card. She is no longer on H4, but she's on I-485 pending authorized period of stay, which is perfectly legal. And you can do what you want. You can quit your job, take a part-time job. Should I wait for 180 days before starting this part-time job? That's a little bit of a different question, but I think you can start your part-time job anytime. Go to our frequently asked questions. I have addressed the issue of how soon can I leave after getting my green card many times. I do it almost on a daily basis. So the law has remained the same. Policy has remained the same. Just take a look at the frequently asked questions. *5. If you have a follow-up question, *5. Okay. So the next question, number 8, is a little bit more complicated. I filed my 485 AOS last year because the dates for filing were current. After 180 days of pending I-485, if I change my employer and if later final action date becomes current under EP2, what happens? Okay. Well, first of all, I do not know if your previous case was also filed under EP2. Nevertheless, let's take your questions one by one. First, after filing AOS for EB3, if the same date becomes current, by the way, before I forget, it is important to understand how this 485 pending 180 days works. The law requires, in order to take advantage of AC21 portability, your I-140 must have been approved and your 485 must have been pending 180 days. What does that mean? Let's say we file your I-140 and 485 in January. And let's say in May, your I-140 gets approved. Now, do you have to wait 180 days from that point forward? No. You have to wait 180 days only from the date of filing of the 485. That means in June, you'll be eligible to use AC21 portability. Can my new employer start a new EB2 green card? Absolutely. No problem at all. Even while the AOS under EB3 is pending, you can start an EB2 based green card with another employer, and you will be able to, not only would you be able to port your dates your priority dates, you would be able to use the same pending 485. Informally, that's called interfiling. Basically, that means you have two I-140s approved and you want to use the one that is of best advantage to you. So no problem. You can use that. I already answered that question about the 485, using the same 485. If I'm on H4 and file extension but leave the country just before expiring H4 EAD, can I continue to work from India but get my salary in the US? Okay, this question is quite unclear, but I can tell you this: you do not need an EAD to work from India. Okay. As to what the tax ramifications, etc., are, that your CPAs can tell you. But you should not need anything, any kind of work authorization to work from India. Can you receive your salary in USA? I don't see any problem with it, but your CPAs should look at the payroll and tax factors in that. Immigration law wise, I see no problem. I have written an article in the Economic Times. I have an author page in the Economic Times, and the link to that is on my blogs. If you go to my blog on immigration.com, there's an article I've written about this ridiculous idea that the US Department of Labor has. If you have an H1B, you have to maintain that H1B to work from India. That's nonsense. That's absolute nonsense. So in my view, they will lose if that case is litigated. In my view, you do not need any kind of work authorization to work from India. Fourth question. My wife is on H1B that expires after a year. H1B, okay. If she wants to amend her H1B for getting a promotion, can her employer file an H1B request for 3 years? So, can you couple an amendment with a 3-year extension? Usually, government they definitely will give it to you if your H1B is expiring in less than 6 months. But if you ask for an amendment and another 3-year extension, should they give it to you? In my view, they should. Do they always do that? No. They are inconsistent, and I think they should make their policy consistent. While you are paying for it, they should give you a 3-year extension anytime you ask for it, as long as you're entitled to it. So the answer is worth a try. Can H4 be also amended along with to get 3 years of approval from now? Certainly worth a try. Why not? Give it a shot. Okay. *5 if you have a follow-up question on this. Press *5 on your phone. No new questions, please. So this call is from California. Okay, California, go ahead, please.
Hello, Rajiv. So here it says after 180 days. Does it work if it is before 180 days and I have my I-140 approved even before that?
Yes, it can. Because if you look at the law, it clearly says that you should not be challenged by the USCIS before 180 days. Because really, the law doesn't require you to stick to the same job for 180 days, but it's safest to do so. We had a case, I talk about it almost every meeting. We had a case many years ago, not many years, just a couple of years ago, out of Minnesota, where one of our clients left their job before 485 was pending 180 days. Government tried to deny the 485. Actually, they did deny the 485. There was a lawsuit filed, and immediately government settled the lawsuit, realizing they were making a mistake, because the law does not require you to be in that job for 180 days. It requires only that the 485 continues to be pending 180 days. Clear?
Yeah, thank you. And one more question on that. So can I file AC-21 after 180 days is complete? With the
Absolutely. Absolutely. Supplement J, which is AC-21, definitely file it after 180 days. Do not file it before 180 days. Okay?
Or shall I just wait for the RFE to come in for the 485?
I like to file supplement J's as early as possible. That's my practice, and that's a whole another discussion. Let me take the next call, sir. Good luck to you.
Okay.
All right. Bye-bye.
Mm-hmm.
So I think the next one is from Atlanta, right? 770? Okay.
Yes.
Okay,
It's from
sir.
Atlanta.
Yes, sir. What is your follow-up question?
So the question is that the I-140 is approved. The I-485 is pending for more than 180 days.
Good.
Now, like under the EB3 category. So now for the same priority rate, if the EB2 becomes current, so because EB3 might take maybe 5-6 years to become current under action date. So if EB2 become current, is there any way to utilize that?
Yes.
By
Absolutely.
or something like that?
Absolutely. Absolutely. If you already have an EB2 I-140 approval, all you do is send it in to the government and request you are going to use 485 with the EB2 because the date is current. Okay?
No, I do not have the EB2 approval, but I do have the EB3. So
Then you
upgrade it.
Then you need to upgrade it. Yes, sir.
Okay. So
Okay.
Upgrade and also return the priority date even though it was already filed for the I-485.
Priority date is not a consumable product. It is not like a banana, you eat it and it's gone. Priority date is good forever.
Oh, okay.
Okay.
I see. Okay. And the next question is that that if the amendment if the H1B is expiring within a year, like maybe more than 6 months, but within a year. So now if any promotion happens, or maybe if buying a new home or moving to a new home, to add that address for the remote work purpose, so can the amendment be requested for 3 years, like instead of up to the validity of current H1B?
I just answered that question 3 seconds ago. I just answered that question that the government's policy is not consistent. Okay?
Okay.
Good luck.
All right. Thank you so much.
You're welcome. Okay, so the next question is I-131 Reentry Permit, N470 and COVID. Wow. So I'm working in India for an Indian subsidiary of a US headquartered company. Reentry permit is expiring in June. Currently in India, I need to enter USA before June 20th. White House has put a travel ban. You can go to another country for a couple of weeks and then enter USA. Why not? Well, returning resident visa can work, SB1 can work, but here is what the government has said. I don't want you to test this, okay? I want you to find a way to go to a third country and come back into the United States before June. That way you can apply for your re-entry permit, and if you need to, you can leave again, or wait till your biometrics are done, get your shots, and then go again. Your question about the N470, I am not sure I can give you a good answer. I have to look at the law. I'm pretty sure you cannot transfer N470. You have to file a new one. But as far as you're coming into the United States is concerned, I want you to do that. There are some relaxations by the government on travel by people like you. But like I said, I don't want to test it. I want you to just go to a third country for a couple of weeks and then come into the United States. If you want to explore those options, which means just taking a flight and testing what CBP does, you can set up a call with your lawyers, talk to them, but I would not advise you testing that. I would rather have you come in. *5, if you have a follow-up question, *5. This one is from India. Arjun, is that you?
Yes, Rajiv, this is Arjun Ganesh from India.
Haan ji, Ganesh ji.
So, thanks. Yeah. So, Rajiv, in the proclamation from White House, they have made an exception. I just said it after posting this question. There's an exception applied to the lawful permanent resident of United States.
Oh yeah, sorry. Thank you for correcting me. Yes,
okay.
You do not actually need to go to a third country.
Okay.
For a moment I forgot you're a green card holder.
Okay.
Yes, of course. You are not subject to the ban.
That's right. Yeah. Only one thing is, right now, the situation in India is getting very, very bad. People are not even coming out of the house.
Yeah.
So let's say if I don't come before June 30, maybe July or September, right? So let's say September, things say September will get improved.
That's a discussion. That's a discussion I want you to have with your lawyers, because there are many ramifications and many issues. This is not something I can do in a community conference call. So talk to your lawyers.
Got it.
You know the basics. I would rather have you come in before May. Okay? Before June. Okay.
Before June. Okay.
Yes, sir.
Okay. And just one thing on the SB1, right? I just, based on your experience, is SB1 getting approved? In case if I don't come before June 20.
I can only guess. Okay. These conditions are dire. They should approve SB1s much more freely than they used to. Will they? I do not know. Should they? Yes. Will they get sued eventually if they start denying too many of these cases? Probably. So I think it's a good case, but it's by no means a guaranteed approval case. Okay?
Got it. If I apply for it,
sir, I gotta go.
Eventually I have to apply Reentry Permit again? Yeah, okay.
Yeah, you'll have to come to the United States, get another Reentry Permit to protect your green card. Okay?
Okay.
Good luck to you.
Okay,
sir.
after I got SB1 approved. Okay, got it.
No, not after SB1. Well, once you get SB1 approved, basically you've reinstated your green card. If you're going to leave again for a long period of time, you will have to get to some way to protecting your green card. But the way you are going, you could lose your green card. Okay. You need to talk to your lawyers, because this has to be planned right. I'm not at all sure that such extended absences are defensible. So please talk to your lawyers. They need to look at your entire background to give you good advice. Okay? Good luck.
Sure. Thank you.
All right, sir. I think this one is from Richmond, area code 804, right? Where are you calling from?
Hello, sir. I'm calling from Richmond, Virginia.
Yes, ma'am. What can I do for you?
My question is, my husband is on H1B visa. Mm-hmm. He is in India right now. Mm-hmm. He went in the month of March. Mm-hmm. And my son is a US citizen.
Uh-huh. So okay, ma'am, I'm not answering. Ma'am, I'm not open to answering all questions right now. Wait until the end of the call. I'm only taking follow-up questions. Okay, don't ask me random questions, guys, until I come to the end of the call where I ask for all questions. Right now, I'm just answering the posted questions and anything that stems from those questions. So here's a felony charge, question number 10. My F1 OPT ends on June 2021. I've got a felony charge. Things are moving slow in the criminal courts. Can anything be done to get at least a work permit? And the answer is, I don't think so. However, you are entitled to an H1B, okay, if you get through the lottery, because until you are convicted, you don't have anything that stops you from getting an H1 or even an OPT, STEM OPT if you are entitled to it. Okay. So those two things. Another thing I would recommend very strongly is when you have a criminal charge against you, make sure that your criminal defense lawyer coordinates with an immigration lawyer in the state where you are located. Okay. They should work together to make sure you are protected. *5 if you have a follow-up question. *5. No new questions, please. Only follow-ups. All right. Question number 11. Oh, I'm not going to be able to answer that. Sorry. We don't do U visas. So I have no idea how U visas work, nor have I ever looked into it. Question number 12. Options to move decisions for 485 AP I-140 downgrade filed October 2020. Not sure what that means. I applied for 485 I-140 downgrade 765-131 in last week of October 2020. Waiting for biometrics. Nothing is happening. I-140 upgraded to premium, waiting on acceptance. Since I-485 would be pending for 180 days, can we use AC-21? I just answered that question. Not until I-140 is approved. Is there any defined reason for processing times for these things? Look, delay cases are usually difficult to win unless there is a whole lot of people delayed and they are delayed beyond reason. You should open service requests, USCIS ombudsman requests. Nothing is stopping you. Mandamus cases are difficult to win. Not impossible, but difficult to win. Doesn't hurt. If you have a group of people you want to file a lawsuit, by all means do that. Not easy, but worth trying. If priority date is likely to be current in September, October, and none of these things, what other options are there? And there are no other options other than, like I said, you have those already: lawsuits, service tickets, ombudsman's tickets, congressman approach. I do not think that under the current circumstances any of those are particularly powerful options, simply because the government is quite backed up, and that's a systemic issue. Towards the end of my conference call, okay, I don't know what that is about, Rahul. *5 if you have a follow-up question, *5. Okay. Then the next, question number, 805. Area code 805, where are you calling from? 805. Yeah.
Hello, sir. Hello.
Yes, ma'am.
Hello.
Mm-hmm.
Hello, sir. I'm calling from California.
Yes, ma'am.
My question was number 7.
Number 7, I have already answered, haven't I?
Was,
Haven't I already answered that?
yes.
Okay.
Yes, I had a follow-up question with that.
Okay. Next time, if you are ever here, please don't delay it, because I can't keep going back and forth. Okay. So I'll make this exception for you this time, but I have to proceed in a very organized manner. So I have to go back and read your question again. Okay. So let me hold on one second. Okay. So husband is approved and wife is pending. All right. What is your question?
Sir, as my currently EAD is not sent out, but at the same time we had also applied for advanced payroll.
Mm-hmm.
So my question is, while they have not sent me the EAD yet, will the advanced payroll will be independently be sent out before EAD? Or it is like it comes together? Or
it comes together, as far as I know, ma'am, it comes together in one document. It looks like a driver's license.
Okay.
It contains both your advance parole and your EAD. Okay?
Okay, sir. Thank you so much.
You're welcome. Good luck. Okay, next question is from, hang on, I hope it's a follow-up, because I'm not answering new questions. I don't know where I was, guys. Let me get to that point first. Okay, I don't know anything about this. We just did this one. Okay, I'm at question number 13. Area code 608. Where are you calling from, 608?
Hello.
Yes.
Yeah, Namaste Rajiv ji. This is Rahul. And I have a follow-up question. हम लोग पहले बात कर चुके हैं.
जी.
So my question is, let's say I-140 gets approved through the premium, but the EAD has not arrived yet. Then do you still have to go through the H1 and all if one wants to switch over to a same or similar job?
Well, that depends upon how soon you want to start working. Because
okay,
let's say your I-140 is approved, 485 has been pending 180 days, and you want to change jobs.
It's already pending 180 days.
Okay, let me finish. You want to change jobs.
Sure.
Okay.
Sorry.
Now the problem is you can change jobs, you just can't start working. To start working, you need either an H1B or you need an EAD. So don't confuse the two procedures. One moves you over to a new job, the other gives you permission to work. Two different things. Okay. So you will either need to do an H1B transfer or an EAD to start working.
Okay.
All right.
Basically, you'll have to waiting for EAD.
Exactly.
If you don't want to go through the H1B stuff.
Yeah, I would do the H1B. It gives you more protection. I would do the H1B. No question in my mind about that. Okay.
Okay.
Good luck, Rajiv.
Have a good day.
You too, sir. Bye-bye. Then we come to question number 13. So the question number 13 is, I'm currently on Cap Exempt H1. Somebody is filing Cap Subject H1. If the Cap Subject H1 gets approved, will my Cap Exempt H1 be invalid? Absolutely not. It will be valid. Should I have to start working with my current Cap Subject employer as soon as it gets approved? No. As far as I understand the law, if you are working on H1 already, it's Cap Exempt, your Cap Subject gets approved, whatever date, you actually have two choices. You can continue working at the old employer or move over to the new employer. Can you work for both together? Only if you apply for Concurrent H1. You can do both, but you have to have a Concurrent H1. What does that mean? It means one of the cases will have to be refiled, whether the old or the new employer's case, and you have to check mark a box, Concurrent Employment. While this is pending, can I travel to Canada and get my H1 Cap Exempt stamping done? That's a tough question to answer, because are you applying for a change of status? No. Are you applying from H1 to H1B? Look, I would rather have you finish your H1B and then go for stamping. I personally think it's not a problem. I can't think of anything, but there is a tricky problem here. One is a Cap Exempt, one is Cap Subject. You are not really asking for a change of status. If you were going from F1 to H1, you couldn't travel. But you are going from H1 to H1. You should be able to travel. But I'm hesitant to test these theories. And what is the point? It doesn't take long for the approval if you file it premium processing. Star 5 if you have a follow-up question. Star 5. Okay. Area code 513. 513, where are you calling from?
I'm right now sitting in Minnesota, Rajiv.
Minnesota. Acha ji. How can I help you?
On the follow-up on the second question, so let's say if my Cap Subjective H1 gets approved, I can still continue to be on my current employer, which is Cap Exempt.
Yes.
And if that's not, if the new H1 is not revoked by October 1st, I don't have to go into the auction again. Is it accurate?
That is correct. That is correct.
Okay, and then on the fourth question here, let's, I know you answered this, but just to get more detail out of it. So right now my lottery was picked and I haven't applied yet.
Okay.
Would that make a difference if I go for stamping either Canada to Mexico for my Cap Exempt H1 before I apply for a Cap Subject?
You have to
I send in papers for Cap Subject, or
you have to be in the United States when your Cap Subject H1B is applied. Other than that, I'm very uncomfortable answering this question. Have your lawyers look at it. Make sure you talk with your Cap Subject H1B lawyers. I don't think it's a problem, but don't take my word for it. Talk to them. Okay?
Okay, thank you.
Good luck. Okay, so next question. This is from Nidhi Singh. I got my H1B stamped last month. Never been to the United States before. LCA says I'm working from Rosemont. Company wants to send me to Bloomington. Do I need to get an amendment? Absolutely. If you are not within 50 miles of an approved location. By the way, I don't like this idea of getting an H1B approved with a company address, because that usually means the company has misinformed the government, usually, not always, that they have an in-house project. And USCIS considers that to be fraud. Okay. So if the company files an H1B saying, oh, we have an in-house project, we are developing a product. But then once the H1B is approved, they start marketing your resume and they bring you in for another location. That's really fraud. Okay, so be sure you're not in that situation, because you could have an H1B declined at the airport. They could turn you back and you could have problems later on. Make sure that's not your situation, Nidhi. But yeah, you need an amendment. Can I fly to my client's location once amendment is filed and under process? The answer is yes. Yes. Because, let me think about this. If you are in the United States, I'm sorry, I take it back. See, if you're in the United States and you file an amendment, you can start working at the new job as soon as the amendment is filed. But if you're coming from outside the United States, I am not aware of any law that permits you to do that. Okay? I don't think you can. If I fly with a visa that has an amendment under process, I don't think you should fly in at all, Nidhi. I think you should look at, first of all, this issue which I mentioned. Have they filed it as an in-house project, and are they now trying to convert it as a client project? If they are, quit this company, get another job. You're not subject to the quota any longer anyway, right? So I am just concerned that you're not heading into a messy situation. *5 if you have a follow-up question on this. *5. Okay. So this is the last question, and then we'll open the floor to new questions. Working for employer A on H1 with pandemic, they were not able to continue to pay. So I applied for unpaid leave of absence. It was a rough time. Unpaid leave of absence doesn't maintain your status. Anyhow, I found new job 5 weeks later, working for employer B. Now A would like to get you back. Since I have a full-time job with B, I want to do only 20 hours for employer A. They have not withdrawn my H1B. They have to file an amendment, yes. They have to file an amendment. Current employer B wants to wait to do my green card, but employer A is willing to start. Well, there is no law that says you have to have a full-time job to start your green card. You could do a green card with employer A, but the problem is make sure they have enough money to prove they can pay your wages. That's a long issue, I can't get into it, but have your green card look at what is called ability to pay wages issue with employer A. But can they do your green card? Absolutely. *5 if you have a follow-up question on this. *5. Okay, anyone has any question, please press *5 on your phone. Any question at all. Press *5 and I'll start taking the questions. I have 1, 2, 3, 4 questions only. Alright, we'll answer the 5 questions. 6 questions. Wow. Okay. So we have 6 questions that we need to answer. Let's begin with area code 513. Area code 513, where are you calling from? Area code 513.
Hi, can you hear me, Rajiv?
I can, sir.
Oh, this is a follow-up question to number 13.
My question is, where are you calling from? Can you answer that?
I'm Minnesota, sorry.
Okay, Minnesota. Question number 13. Cap Exempt Cap subject. Alright, sir. What is your question?
Let's say my cap subject H1 is approved. When I go out of the country, I don't have stamping for my cap exempt and cap subjective. So which one? If I continue to stay on cap exempt, I go get the cap exempt stamping done.
Right.
And not the cap subjective one, correct?
Naturally. So what is the question?
And if I decide to move on to cap subjective H1, should I have to go back to the stamping again?
I do not believe so. I believe you should be able to, the stamp is not attached to a particular employer. you can travel with company X's visa stamp and company Y's approval notice. Whether they were cap exempt, cap subject, doesn't matter. Okay?
Okay. And the other question is, let's say
you're gonna have to look. There's a lot of people waiting. I'm gonna give you 10 more seconds. Ask your question quickly and move on.
Sure. My cap subject is approved. Now can I go to Canada or Mexico for my cap's exempt stamping?
Yes, you can.
Approval.
Yes, you can, because you have two approvals. You have two approvals. Okay.
Okay.
Good luck, sir.
Thank you, sir.
You're welcome. Area code 716.
Hello, Rajiv. Thank you for the opportunity, and I'm calling from India at the moment.
Anji, ma'am.
We have our I-140. We have our I-140 approved as of last week.
Achha.
But we completed our six-year term in the US, and we have completed the 1-year term in India.
Achha.
And given that our I-140 has been approved last week,
right.
What is the means to get back? Is it the previous H1 needs to be resurrected?
Yes. Yes.
Or
yes.
And will it be a cap
yes.
cap exempt? Or
okay. Let me take over. So what you will do is you will resurrect your old H1B, and you will be entitled to a 3-year H1B extension unless your dates are current. If your dates are not current, you are able to get 3-year extension without being subject to the quota. Okay, but why would you want to be subject to the quota at all? So just go with using the I-140 approval, get a 3-year H1B extension. Okay.
So we can go, instead of H1B, we can directly take the I-140 approach, or it has to be resurrected for us to get back to the US?
There is no direct I-140 approach. You have to come back to the USA on H1B. The question is, how do you come back? Okay. There is only one way. You use your I-140 to get 3-year extension, H1B extension.
Okay, and the employer will be supporting it to get back.
Absolutely.
H1 to resurrect.
Absolutely. Okay.
Okay.
Good luck.
Okay. Thank you, Rajiv. Thank you so much.
You're welcome. You're welcome, ma'am. Area code 562. Where are you calling from? 562. Where are you calling from? Area code 562. I'm gonna skip this.
I'm sorry. Hi.
Yeah. Go ahead.
Oh, I'm sorry. Hi, how are you?
Good.
I'm calling from California, and thank you so much for this. It's been really helpful so far.
Yes, ma'am.
So I had a quick question about my status. So basically, I was on my H1B up until 2020, like early May, and I lost my job due to pandemic. So I kind of applied for the change of status upon the suggestion of an attorney to B2, like a visitor visa, just to stay in status, and I wasn't comfortable traveling around that time.
Okay.
And then that kind of expired towards the end of January, more or less, and I applied for an extension. Right now, I'm on an extension of B2 visa, and that expires in the first week of June. First week of June. So I was just wondering, since with all the travel restrictions right now, is there? I mean, is there an alternative to like a stay of extension at this point?
Well,
or,
you haven't received a denial of any extension, have you?
No, the first one that I've applied, that's yet to be adjudicated at all. I mean, I haven't heard anything back from that.
So hang on, ma'am, confine your answers to the question I ask, because I need very specific information. Okay. So if none of your pending cases have been denied, and the cases were daisy chained so that there is no gap in the B2 status, you can apply for a second extension. Okay. So that's the only thing you can do. It's expiring in June. Apply for another extension from June to December. Okay.
Okay. So that's possible. I'm sorry, is a follow-up question allowed for this?
Sure.
I don't want to take up other people's time.
That's fine.
Okay, thank you. So Well, I guess I did not mention that I'm also simultaneously trying for jobs, and since I was
Sure.
on H1B, I was suggested
Sure.
that I will be able to switch from B2 to H1B.
Okay.
If something works out, is that still possible even with the second extension?
I doubt it very much, because when you are in between statuses, the government does not give you H1 within the United States. Most likely scenario is they will approve your H1B but ask you to go get your visa stamping before you can start working. At that point, you could go to any country that's open and get a visa stamping and come back. Okay?
Okay, so it's not completely impossible. That can be worked out.
Very unlikely. We have won a lawsuit, well, actually settled a lawsuit on a similar issue, but that was a very specific set of circumstances where they gave me the H1B approval, denied my status, and I said, hell no, you can't do that. So we filed a lawsuit in Washington, D.C. 3 weeks later, they approved our case. So that was a very unique set of circumstances. I think you could do that, but hey, it's easier to just go outside, get a visa stamping than sue the government. All right?
Of course, okay. And this is all in case, there's no change of status at all, like there's no adjudication in picture. Okay?
Look, it's highly unlikely that you are going to get 2 approvals or 3 approvals while the H1B is going on, but it's possible. So give it a shot, but definitely you need to apply for another extension. All right?
Okay, sir. Thank you so much.
You're welcome.
Okay.
Area code 408, California. Go ahead, please.
Thank you, sir. My question is a little bit related to the 485 I already asked. So I filed 485 in October last year.
Okay.
And I got terminated in February.
Okay.
And after that, I got joined another company after a month.
Okay.
And in March, I got my biometrics done.
Okay.
And I haven't heard anything after that. So my question is am I within still status? Does getting bio prove anything?
No. So let's take a look at your situation for a second. Let me focus on some very specific issues. First of all, your I-140 is approved, correct?
Yes. That was approved long back, 2012.
Okay, good. When you filed the 485, you were still working for the sponsoring company?
Yes.
Okay. You got laid off how many weeks after filing the 485, approximately, or months?
I'd say 10 weeks.
Oh, good. Okay. So, has your 485 been pending 180 days now? It has, right?
Yes.
So, you are extremely safe right now. Really, really safe. Okay. All you need to do is procure a job or a job offer by the time the government asks for it. Okay. So, what does that mean? So, once your 180 days are crossed, you are entitled to AC-21 portability. Correct? You can transfer your jobs to same or similar position. Remember, you don't actually have to have a job. You have to have a job offer. Okay. So, let us say that 2 weeks from now, you get a notice from the USCIS saying, submit supplement J because it looks like you have left the old employer. At that point, you have, 87 days? Almost 3 months to get a job offer. Supplement J. Supplement J is simply a job offer. Got it?
Yes. I joined another employer right after I laid off.
So you have no problem.
So I joined another employer.
Why are you calling me? You have no problem.
So okay, that's good. So I can file my 485 AC-21 with my new employer.
Sir,
won't be any problem.
You'll be filing supplement J as in John. Supplement J. Okay?
Oh, supplement J.
Okay. You don't have to file 485 again.
And
yeah. And would there be any problem?
So
Hang on. Let me at least answer your question, Bhai Sahab.
Thank you.
Would there be any problem? I can't predict that. But we have done, if not thousands, several hundred AC-21 portabilities. I've never had a problem, not one, except in one case which I just mentioned, where they tried to deny the case and then they lost in the lawsuit. So I do not anticipate any problem, but your lawyers can best guess that, judge that for you. Go ahead with the rest of your questions.
Yeah, can I use your service to file the supplement J?
Yes, sir. Absolutely. Absolutely. You can send me an email to help@immigration.com. Just say, Rajiv, I spoke with you today. Can we start the supplement J for me? I will have somebody contact you. They'll tell you the fees, etc., and we'll take it from there. No problem.
Oh, awesome. Thank you very much.
Absolutely.
That helps. And can we use this supplement J for employment, or it cannot be used just for status move?
No, supplement J is not used to, it's not employment authorization. Supplement J is simply, think of it as a job offer letter. That's all it is.
Okay.
Okay.
Got it. Thank you, sir.
Oh, you're welcome, sir. Good luck. Let's go to area code 805. 805, where are you calling from?
Yeah. Hi, Rajiv. This is calling from Illinois.
Yes, sir.
It's related to question number 6.
Anji.
Yeah, this is I'm calling you for my son. So he is actually a full-time student in the university. He's doing a 3rd year.
Yes, sir.
STEM degree.
Right.
He also received his EAD card as part of the downgrade process.
Okay.
But since he's turning 21 in August, right?
Mm-hmm.
I asked him to file for his F1 change of status, which is still in process. It's not approved yet. But he turns 21 this year. But what if his F1 change of status doesn't happen in time? Even though his EAD card is valid till next year, can I file a B2, something like that?
Well, why? Because as long as his 485 is pending, he is not illegal in this country.
Okay.
Okay.
But he has this problem with turning 21, right?
So what?
Under
So what?
21 or not.
Until the government moves to revoke his 485 and actually revoke it, he is legal in this country.
Okay, got it. Okay.
Okay.
So it's
And,
better for him to just
and
continue
frankly,
that,
one
right?
second. I have an idea. There are so many of parents like you in this country. Organize yourselves and make a request to the Biden administration as a matter of policy not to revoke 485s of such children. That will give everybody a lot of benefit.
Okay.
Okay.
Yeah.
So I think that is a great way to go. Organize yourselves and write letters, meet with congressmen, get them to see. Because remember, under the new laws, they have recognized the problems faced by the aging out children, and they are trying to address them several ways. So they should be sympathetic to, by policy, not revoking 485 of these kids, so they can, because on 485 they can go to school, on EAD they can do jobs, internships. I think it's a great benefit. They should continue it. Okay.
Yeah. But Rajiv, in case there are any issues, right? If they come back with that law saying he's already turned 21 and they,
then you do an F1. Then you do an F1 or an F1 or an H1B, because by that time this young man would have finished his degree. He's entitled to an H1B.
Okay. Yeah, I already have applied for F1. Yes, already.
And also, once you get your green card, you can also apply for him. He's an unmarried child of a U.S. Immigrant. You can apply for him too. Okay. So there are several options, but the next step is quite clear. I don't see any reason for you to worry until the 485, because before they even revoke the 485, they have to send you a notice of revocation. Notice of intent to revoke, and you respond to that. So you have time to adjust this. At least for these kind of kids, what I have seen is, even though if you have an immigrant intent, you are not allowed to get F1 student visa, etc. But consulates have been very generous. All these kids are coming back with student visas.
Yeah. So, so F1 and F2, all those takes a long time, right? So can a B2 visa cover that,
No, B2 visa is a lousy visa.
scenario?
B2 visa is a lousy visa in this circumstance because if he wants to finish school and if he's under revocation, he needs an F1 visa. So I think it's a little bit, you're worrying about it a little bit too far ahead of time. When you see a notice of intent to revoke, call me.
Okay, cool.
Okay. Good luck. Good luck.
Thank you. Thank you so much.
You're welcome. Last question of the day is area code 347. Area code 347. Where are you calling from?
Hello, Rajiv. I'm calling from New York.
Yes, sir.
Thank you for giving the opportunity to speak with you directly.
Absolutely.
My question is, I'm currently on H1B visa.
Yes, sir.
And I recently got a job offer from another company, and they filed my H1B transfer application.
Okay.
But unfortunately, I received RFE, and my new employer is in the process of filing the RFE response.
Yes, sir.
But the problem is my new employer also changed their name. So the name from company A to company B. The company is same, they just changed the name. Should I inform USCIS about the new name, or should I keep it my petition with the old name?
I can answer that question generically, but specifically you should check with your lawyers. All right. So first thing is, just a change of name is no consequence at all. If the tax ID remains the same, job offer remains the same, I don't see any problem. Okay. But if there is a restructuring of the company of some kind, then your lawyers have to reassess what they need to do. That gets complicated. Name change, no problem at all. Okay.
Okay. And just a follow-up small question related to this.
Sure.
It's just a name change. Nothing else is changed. My manager is same. Organization, everything is changed.
Right.
So for example, let's say if I don't inform USCIS right now and I go for my visa static 6 months later, is there anything which I should take care of?
No.
Is there any document I should present to?
No, hang on. So what we do in these cases is, assuming that you have no restructuring, just a name change, we will typically send you with a letter from the employer saying there was a name change and nothing more, same tax ID, and here is a copy of the corporate filings showing a name change. And so we send our individual clients with copies of the name change proof, and that's all. So you'll get a visa stamp under the new name, but you have an approval under the old name, but you have evidence showing that they are the same company. Okay?
Okay, right.
Not a problem.
Thank you so much.
You're very welcome. Well, folks, it's great talking to all of you as always. I'll see you again in 2 weeks. Good luck and thank you for being here. Bye-bye.